What you think you know about the arrests of Bhagavan Nithyananda Parma Shivam is almost certainly based on media headlines. But here's the thing. The official, legally binding court records, they tell a story that is radically different. The documented facts don't just challenge the popular narrative, they completely dismantle it.
Let's just dive right in with the single most stunning piece of evidence. High Court Order Number CRLP 3253/2012 says something the media never told you. While the world believed one story about the 2012 arrest, the highest court in the state of Karnataka used these exact words to describe it: illegal, without any authority, and contrary to law. Now, that's not an opinion, and it's not an argument. It is a final legal judgment. So, to be perfectly clear, what you're about to see isn't based on hearsay or someone's opinion. It's the result of a direct analysis of the primary source documents themselves, the court orders, the case files, and the legal proceedings that make up the official record. So let's get into the documented facts, and we'll start with the huge gap between the public story and what that official record actually says. Okay, so first things first. We have to put the story you've probably heard a million times right up against the story the documents actually tell. The difference is pretty shocking, and it really sets the stage for everything else we're going to look at. And right away, you can see just how different these two stories are. The media narrative was simple, easy to repeat, arrested for rape. But the official documentary record, it's way more specific. The 2010 case file shows that the very first complaint, the document that started this whole thing, never once used the word rape and didn't name a single victim. And the 2012 arrest? Well, the court record shows it wasn't for rape at all. It was for an alleged breach of peace. And remember, that's the same arrest the High Court later ruled was illegal. All right, let's zoom in on that 2010 arrest a little more. It's really important to see how this case was actually started because the case file reveals some highly unusual steps were taken right from the get-go. You know, a timeline analysis of the official record shows just how shaky the foundation of this case was. So on March 4th, 2010, a complaint is filed. But again, the document has no victim's name, no allegation of rape. 3 weeks later, the High Court denies anticipatory bail, saying there was no reason to fear an arrest. But then he is arrested on April 21st. And then, get this, nearly 2 months into the investigation, on June 11th, the police themselves submit a memo to the High Court admitting something incredible. Not a single witness had come forward to give evidence. Now, think about this for a second. Instead of investigating a crime that was reported by a victim, the case file for March 29, 2010, shows that public advertisements were taking out, asking for people, literally anyone, to come forward and give statements after the case had already been filed. This action, soliciting for victims, isn't standard procedure. It's a critical and, frankly, a very strange detail in the official record. Okay, so that was 2010. Now let's turn to the 2012 arrest. Because if the start of the 2010 case was unusual, the events of 2012 led to an even more powerful and definitive ruling from the Karnataka High Court, one that left absolutely no room for interpretation. The sequence of events documented here is just wild. So Bhagavan Nithyananda Paramashivam holds a press conference to present his side of the story. That press conference is attacked, but then the legal proceedings document a complete reversal. Instead of arresting the people who caused the violence, the police arrest the victim of the attack, Bhagavan. He gets bail on June 14th, but is immediately rearrested under what are called preventative detention laws, a move the High Court would later come down on hard. And this brings us back to the court's own words from High Court Order CRLP 3253/2012. The language here is just so blunt. The court says it is not able to understand the legal reason for the arrest. The judges point out that the laws used were for preventing crime, and they don't actually deal with any offense. So the key takeaway is that the High Court itself, in its official ruling, completely invalidated the very authority of the police's actions. So what we're looking at here, as documented in the court records, aren't just a few procedural mistakes. They point to specific, serious violations of established legal procedure and what international law calls fundamental human rights. Let's just connect the dots here, fact by fact. The 2012 preventative arrest misused specific sections of the law. This directly corresponds to a violation of Article 9 of the Universal Declaration of Human Rights, no arbitrary arrest. The way the 2010 case was handled, as shown in the files, challenges the presumption of innocence, which is guaranteed by Article 11. And impounding Bhagavan's passport, well, that violated the right to freedom of movement, a right protected under Article 13.
Okay, so we've gone through a lot of court orders and case files for both arrests. Let's just pull it all together and summarize what the documentary evidence conclusively proves. These are all the key, undeniable takeaways from the official record.
So here it is, plain and simple. These aren't theories, they are facts established by the official record. Number 1, the 2010 case began without a victim or a charge of rape in the initial complaint. 2, authorities actually solicited for victims with public ads after the case was filed. 3, the 2012 arrest was struck down by the High Court as illegal. No ambiguity there. 4, the records show the victim of an attack was arrested, not the attackers. And 5, the documents prove that laws meant to prevent crime were misused to detain someone.
And this all brings us to one final, really critical question. On one side, you have a public narrative that's been shaped by years and years of media reports. And on the other side, you have an official record established by court orders and legal documents that tells a completely different story. We've laid out the documented facts. So the question that's left isn't about belief, it's about evidence. Which story holds the weight of truth?